Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this legal education content, please hit the subscribe button. It really helps the channel grow. For today's story, we're dealing with a probable cause search and seizure as it relates to acoustic software that helps to locate the location of a gunshot. We're dealing with what's called Shot Spotter in the case of United States of America versus Terrell Rickman. In this case, the municipality in question was using these microphones that helps to identify gunshots, and then by triangulating the sound, they can determine roughly where it comes from. So the idea is you have a whole bunch of microphones, they pick up the sound of a gunshot, which they recognize on certain frequencies. If it's picked up multiple microphones, they can do some distance location, try to figure out where the shot is coming from, to figure out where to send the police to. Seems reasonable enough as far as it goes. But of course, then we have how that intersects with a particular person. So this particular person was discovered, at least in part, based on this system. So how does that influence the reasonableness of the search that followed? Let's get started with this. Shot Spotter is a surveillance system that uses sophisticated microphones to record gunshots in a specific area. In the very early morning of July the 29th of 2018, Travis Elifritz, an officer with the Peoria Police Department, was patrolling the city in his squad car. At 4:40:02 a.m., the department's Shot Spotter system reported two gunshots coming from 2203 North Ellis Street. When Officer Elifritz received the alert on his computer, he immediately started driving towards the 2200 block of North Ellis. On his way, the officer heard the police dispatcher broadcast the Shot Spotter alert that he had just received. He then heard the dispatcher report a second Shot Spotter alert of 3 more shots fired in that specific area. Okay. So again, we have a system with a whole bunch of microphones. These microphones are set to listen for particular sounds at particular frequencies, namely the shots, namely the sound of a gunshot. And these multiple microphones, once they pick up the sound, can try to triangulate where the sound comes from. And apparently this system was so good, or this signal was so clear, or whatever, that they were able to get down to the purported house number. So that's pretty cool, I guess. It's 2203 of this particular street. So we were able to get pretty specific. Now, how accurate that is, I don't know. But the very fact that they were able to get to this is the house, or reasonably close there too, is pretty impressive for the technology. So the officer sees this alert on his computer. He starts heading over the way there. He then hears the broadcast as he's already on the way, and then he hears that there's 3 more shots that fired. So he's on his way to investigate the multiple gunshots at 4:40 in the morning. What a start to the day. Let's read some more. Officer Elifritz saw a car's headlights down the roads and noticed it was leaving North Ellis to come towards his way. This was the only vehicle the officer observed on the street. Upon seeing the headlights, the officer activated his emergency lights and veered his vehicle into the lane of oncoming traffic. The car occupants pointed backward in the direction from where they came, yelling, "They're down there, they're down there." The officer looked that way and observed a crowd of around 15 to 20 people at a street's dead end, approximately 300 feet from him. The officer kept his firearm drawn. He saw the defendant, Terrell Rickman, in the passenger seat. The driver was the owner of the car. With the driver's consent, the officer conducted a search of the automobile and found a 9mm handgun under the passenger seat where Rickman had been sitting. All right, so the officer is on the way to the scene. He's on the way to the scene, and he sees a car coming towards him. And the car occupants say, "They're down there, they're down there." And then he looks down that way, and he observes about 20 to 30 people standing at the end of a dead-end street, which means that there's one way in and one way out of this particular street. It ends in a cul-de-sac or something similar. So the officer says to himself, well, these people can't really get away if I'm at the end of the street. And these people are also looking suspicious and might be diverting attention. So he pulls over this car. He has his gun pointed at them to stop. They stop and say, "They're down there, down there." It's like, "Do you mind if I look in your car?" And apparently they said yes. And he looked in the car and he found a gun, which might have something to do with the gunshots we heard. Or not, but at least we have something that's relevant. And the driver of the car is the one that where we find this guy. So all right, it's like, so we have found a gun due to the spot shot system or shot spot system. All right, let's read some more. Because of his criminal history, a federal grand jury indicted Rickman for possession of a firearm by a felon in violation of U.S. law. So that's why this would be United States of America versus, in this case, because this is where the feds got involved. So whatever else the local police department might be interested in, the feds are interested in this because of felon in possession. So they'd like to charge this guy as being a felon in possession, whatever else the state might be interested in. Okay. So Rickman moved pro se, so he's acting as his own lawyer, always a good strategy, to suppress the firearm found by the officer, contending that the Peoria Police Department did not have records showing how many shot spotter reports were false positives, and that other systems in the city around the country were inaccurate and unreliable. So, okay, not the worst idea of all time. We don't have enough information to know how accurate this system is, whether or not you were in the right place or not. Now, that may or may not matter ultimately, because even if the system wasn't accurate or accurate enough, the officer was acting in good faith. So this may or may not matter in the end analysis, because the officer was just responding to what the computer told him. So the accuracy of that may or may not be material, but at least it's a reasonable place to start. The system is not accurate enough for you to rely on. There's no data about how accurate it is, and other systems have proven unreliable. Now, what does unreliable mean in this context is also not specified. So what do we mean by unreliable? Exactly. That's also not clear. But he'd like to try to argue that the report was bad, therefore everything that follows is bad. Not the worst idea. It's not going to work, but it's something I would do as a lawyer. I do this. I know it's not going to work, but I'm going to try. So yeah, let's see how that goes. Following the hearing, the district court denied Rickman's motion, ruling that the traffic stop was objectively reasonable based on the totality of the circumstances. The court reasoned as follows. The short lapse of time between the dispatch and the stop, the 911 call of vehicles leaving the area, so that was something else 911 informed him about, vehicles are leaving, the vehicle being the only one the officer saw in close proximity, less than 300 feet from where the shots were reported to have come from, the vehicle driving away from the area where the shots came from, and upon seeing a patrol car stopping and then reversing slightly and moving away from the officer and the driving yelling, "They're still down there," support an initial stop of the vehicle, if for no other reason, to inquire if they were witnesses to the shooting or learn if they had been involved in the shooting. Yeah, so this is Terry versus Ohio all day long. This would be the operative case on point. We need reasonable articulable suspicion is our standard here for a brief investigatory stop. That would be Terry versus Ohio. We don't need probable cause. We need reasonable articulable suspicion, which, as we all know, is a pretty low standard. Perhaps too low, but that's beside the point. It's really, really low. We need something that's reasonably articulable. All right, why do you think that this car might be, what is your reasonable articulable suspicion? All right, well, I got 911 call that a car was leaving. I saw the car leaving. It was relatively contemporaneous with the shots being fired. I thought, and I thought maybe they might be witnesses / involved / the shooter. So I pulled my gun because, of concern of my safety. And they said they're down there. And I'm like, how about I search you? Because you're the only vehicle I see. So, And then I found the gun. Given what we know about reasonable articulable suspicion, you're there. Now, whether or not we should be there in some abstract sense is kind of beside the point, because the law isn't always what we want to be. So, yeah, that sounds like reasonable articulable suspicion to this judge, at least. You may not like it, but that's the legal standard. Great. Let's read on. Under the Fourth Amendment, police officers may conduct a brief investigatory stop, sometimes referred to as a Terry stop. Yeah, it's Terry versus Ohio. If they have reasonable suspicion that the individual is committed or is about to commit a crime. Reasonable suspicion requires specific and articulable facts, which, when taken together with rational inferences, suggest criminal activity. Shots were fired at 4:40 in the morning, might be criminal in nature. I was coming there because of the shots. I saw a vehicle driving away. Could be related to that. it's enough to at least investigate. While inarticulate hunches are not enough, true, reasonable suspicion is a lower threshold than probable cause. That is very true. Again, maybe too low, but that's not for us to decide right now. It's just for us to apply. So, yay. And considerably less than preponderance of evidence. It's not a 50-50 thing. I don't even know what the number is, but it's low. Our task is to objectively examine the totality of circumstances known to the officer at the time of the stop, including the experience of the officer and behavior and characteristics of the suspect. So, again, this is based on what was known at the time, which is pretty much true across the board in law, incidentally. It's like, what did you know at the time? You don't get to be, like, retroactively lucky or retroactively make the right guess. So what matters is what did you know? And how did you know it? And what was your ability to know? That's kind of true across the board. So that can come for good and it can come for ill, right? So a scenario where this would play both ways is, imagine a self-defense shooting. Imagine a self-defense shooting and you shoot a guy who did in fact have intent to kill you, but you had no way of knowing that. He never said anything. So assume that you can establish somehow he had a note, he made a video. I don't know. Just assume somehow you can establish this guy had the intent to kill you. But you don't know that because he hasn't done anything yet. And you have no way of knowing that because you don't know his history and, blah, blah, blah. You don't know, but it's true. All right? So in that scenario, you can't plead self-defense because you don't have the subjective element, right? So you can't luck yourself into that. Now, the opposite of that is true. So suppose that through some series of events, and this is the classic, police shoots the kid with a fake gun, although it doesn't have to be that scenario. It could be a lot of scenarios. Suppose you see someone doing something that overtly appears to be a threat, but it's not, but you think it is. So now you have an objective and subjective belief, even though it's not true. So you have an objective belief it's true, you have a subjective belief it's true, even though it's not true. So in that situation, you can act with self-defense despite the fact the person didn't really mean you any harm. It wasn't really a gun, it was insert whatever, but you objectively could determine it was a gun, and you subjectively would determine it a gun, and anyone would have done the same. So, all that stuff. Here's a good one where this came up very recently in YouTube land. Here's a very specific example of this coming up extremely recently. There was a YouTuber, or wannabe YouTuber, who decided, what would be a really good idea? What if we faked an armed robbery? What if we put on hockey masks and we took butcher knives and we took them to a place where kids play, a business like Kids Zone or something like that. I don't know if it was Kids Zone, but same idea. It's a business that people go to take their kids to play. And what if we go in there and we fake committing an armed robbery? So apparently their subjective intent was not to commit an armed robbery. However, to any reasonable observer, they were committing an armed robbery. They were wearing face masks and they had knives and they said, give us the money or else. And then someone shot one of them and they're dead. Was that a good self-defense shooting? Yes. Yes, it was. Absolutely. So, yeah, it goes both ways. You can't luck yourself into it and you can't unluck yourself out of it either. So the guy who got shot because it was just a prank, bro, well, it was a really, really good prank, I guess. But, yeah, you're dead now. So that would be an example of this. You can't luck yourself into it. So going back to the case at hand, what matters is what was known to this officer, not what was true in some sort of objective reality. What did this officer know? What didn't he know? Did this officer have enough to think that this person might be involved in some sense, even as a witness? Yeah. So could the officer stop them for a brief investigatory stop? Yeah. It's not super hard. Maybe this guy was completely innocent and, somehow didn't know about the shooting and was just trying to go out and start their day because they have a really early morning shift and so they're just going to work or something. But, what's true in reality and what the officer knows are definitely different things. So that's how that plays into that. Hopefully all that was helpful. Rickman argues that ShotSpotter, standing on its own, should not allow police officers to stop a vehicle in the immediate vicinity of gunfire report without any individualized suspicion of that particular vehicle. We generally agree with this proposition. The proposition would be that ShotSpotter by itself is probably not enough. Okay. Indeed, we question whether a single shot spotter alert would amount to a reasonable suspicion of a particular car in particular, right? But we disagree with the conclusion that in this context, the officer had only an unparticularized hunch rather than specific and articulable facts that the car connected to the crimes, such as it was a dead-end street, such as it was the only car that was moving, such as it appeared to be the only car that was there. That made it a little bit more particularized than this is an open road where there's lots of traffic and why this guy? In this case, why this guy? Because he's the only guy. That makes it a little bit different than the abstract case. Rickman is certainly correct that a mere suspicion of illegal activity at a particular place is not enough to transfer that suspicion to anyone who leaves the property, right? A person's mere propensity towards others, independently of suspected of criminal activity, does not, without more, give rise to probable cause to search that person. The key words of that sentence would be probable cause, which, remind you, is not the standard here. In cases where an officer stops a car departing a suspected crime scene, we've considered a number of circumstances reasonable to the analysis. The reliability of any reports to the police, the dangerousness of the crime, the temporal and physical proximity of the stop to the crime, any description of the vehicle and the relevant traffic. What's the probability it's this car? Might depend on what are the total number of cars. And the officers or potential even departments' experience with criminal activity in the area. So, yeah, the officer can rely on any particular knowledge they might have that would help them inform the view that this is the right car. First, and as Rickman concedes, the officer received 2 shot spotter alerts and 2 dispatches reporting to a shooting on the street. The details gleaned from the 911 calls that the dispatcher passed on to the officer highlight that he did not merely act on the uncorroborated information of a single report from the system. Granted, we take Rickman's point so that ShotSpotter is not comparable to an eyewitness or a known informant. Instead, we conclude it's analogous to an anonymous tipster, which is fair. So it's just an anonymous report from somebody. So how reliable is that is going to be the key. How reliable is the report? So when you're dealing with any witness to the police, and particularly anonymous witnesses, what helps you is how reliable. And one of those things are how detailed, how specific. What does it sound like? So this is equivalent to an anonymous tipster, but it's a pretty specific anonymous tipster, so it's something to at least spark the interest. Multiple reported shots fired in the same general area creates a heightened suspicion of a serious crime. The officer therefore had a good idea of what to be on the lookout for when he arrived, between the various reports and the people saying there's a car getting away and so forth and so on. Indeed, an emergency report can support an officer's reasonable suspicion with less objective evidence to corroborate the report. So here, the court is alluding to the idea. There's a sliding scale. Well, I don't know if it's a sliding scale exactly, but what is reasonable is going to be context dependent. That's a better way to put it. So what is reasonable is going to be context dependent. Reasonable based on what? And that applies to your own life just as much as it does to the police. So what you might view as reasonable is going to change from situation to situation. There's not one standard. So in an emergency situation, what is going to be reasonable is going to look a lot different than one in which you have the time for careful reflection and consideration. And you get a lot more latitude, obviously, in making decisions in emergencies than you would in careful reflection, where you can take all the things into consideration. So what the court is pointing out here is that in this particular situation, where there's an emergency of multiple shots fired, sounds like an emergency, and 911 calls sounds like an emergency, the officer, what he needs to form a reasonable suspicion is going to be a little bit different than what it looks like in, say, the life of a detective who has a slightly different posture. So, as always, the facts matter. Third, the officer encountered Rickman's vehicle on the same block of the shooting 5.5 minutes after he received the reports of shots fired, which is pretty good response time for the police for a 911 call. 5.5 minutes. It's not bad. It's below the average for a priority call. Rickman claims that no criminal in their right mind would stick around for a crime scene that long. Well, maybe, but a lot of criminals are kind of stupid. So probably no reasonable criminal would do this, but reasonable and criminal, it's kind of But we're not so sure. We know the shooting continued after the initial alert. There was more shooting. Moreover, this time frame is consistent with others in our case law. Yeah. Common sense counsels that a person may take minutes rather than seconds to flee for any number of reasons, such as them being an idiot, including destruction of evidence, an injury sustained in the shooting, or the need to hide in place. As both a matter of fact and law, then, 5.5 minutes is not unduly long. Yeah, the court's like, the time frame between the report and when the officer found you is essentially contemporaneous, which it is. This wasn't an hour later. It wasn't a day later. It was 5.5 minutes. So, yeah. Rickman's vehicle was also driving away from the site, on the only street leading from it. So we know where it came from because it's a dead-end street. Where did it come from? It came from the crime scene. How do we know? That's the only place it could have possibly come from, because dead-end street. Yeah. The officer did not have a description of any vehicle. However, it was 44:45 in the morning and there was no other traffic. In this scenario, the hour reinforces suspicion because we realistically expect few people to be on the road at the time. And finally, the officer knew that he was headed towards a block that he once patrolled and where in the past he's responded to shots fired calls. Indeed, he estimated that he responded to these couple blocks once per night. He was, of course, right to draw on his own experience and specialized training to make inferences from and deductions about cumulative information available that might well elude an untrained person. Okay, so one of the things that an officer can rely on is their own training and experience. Great. What was this officer's personal experience? Okay, let me tell you about my personal experience. I used to patrol this specific area. I don't patrol it anymore. I just happen to be nearby at the time. But I used to patrol this specific area, and I used to be called to these streets every single day. So, I have some familiarity with them. Court's like, yep, sounds good to us. For the reasons stated above, the district court appropriately denied the motion to suppress. We therefore affirm the resulting conviction and sentence. Thus, that brings us to the end of the case from the Seventh Circuit of United States of America versus Terrell Rickman, coming out of Illinois. In this case, there was a report of shots fired that was captured by both an automated system, the shot spotter, and 911 calls. The officer went to the location that was pointed out by the computer and the 911 calls. The officer, once they arrived, saw a vehicle attempting to leave a dead-end street and stopped them at gunpoint because they really wanted them to stop, and then searched the car and found a gun. Now, how this resolved in terms of the state law, I don't know. So was the gun tested? Was someone shot? I don't know. None of these questions matter at the moment. Our immediate question is felon in possession. So did the officer have reasonable articulable suspicion to stop the car? Because remember, he had consent to search. So that's out of the window. So if he had searched without consent, we'd be asking a whole different set of questions. But we're not asking those questions because the guy said, yes, please search my car. So we don't need probable cause. So we don't have to worry about that part. Yay. So let's just worry about stopping the car. Did we have reasonable articulable suspicion? Yes, we did. Can I search the car? Yes, because they said I can. Great. That was easy legal analysis. And for the moment, at least, that brings us to the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.